Thank you very much. I'd like to open up. This is technically the open committee meeting of the Case Administration and Estate Committee of the American Bankruptcy Institute's Commission on Consumer Bankruptcy. We appreciate everyone's attendance. My name is Bruce Markell. I'm the chair of this committee. We're a little short on time, otherwise I would introduce all of the very talented and accomplished members of the committee, but you can see from their placards up here their names, and if you want to run down their backgrounds, it's all on the ABI's website. We're also graced today with the presence not only of our speakers who will be talking with us, but also members from the commission itself. Again, but time precludes me from introducing them individually. The format today is that we will hear from various people who have both given us statements, which I am told are up on the ABI website in writing, and also we'll talk to the committee today. We've talked with them about certain time limits, and so they know the restraints that they are under. And then at the conclusion of their, again, this is like a long way. I feel like I'm at a peace conference talking to someone on the other end. At the conclusion that the committee may have comments, because again, all this is going towards hopefully a crackerjack report to be authored by my good friend Bob Lawless of the University of Illinois, someone who I will introduce because he is a really stellar addition to the commission's work product. And so we're all here because I think we're interested in consumer bankruptcy. We're all here because we're interested in improving consumer bankruptcy. And again, with respect to our committee, we're looking at things that don't go directly to Chapter 7 or Chapter 13, but if you will, the general administration of consumer bankruptcy in courts. Our first speakers are the Honorable John Waits from Charleston, South Carolina, and the Honorable Rebecca Connolly from Harrisburg, Virginia. I'll turn it over to them, and they can give us their statements. Judges.
Yes, thank you very much. I appreciate the opportunity to speak today. I do not consider myself an expert in consumer law, but I've been on the bench for 23 years, beginning my 24th year. So I submitted to you a short list of suggestions, 4 of which I would consider more or less statutory clarifications or corrections, and then 2 of which are more policy-oriented. In regards to the first category, I have been to some of your meetings and I've heard the chorus of folks that I agree with, and that is the pre-petition credit counseling requirement is, as a means of determining eligibility for filing, is really not useful and really effective. It's just something else a debtor has to do at a greater expense. And for the most part, it's not very helpful in my cases. Second of all, I would raise to your attention the issues associated that you're aware of, the discharge provisions under 1328. And that the issue is whether a debtor who's failed to make direct payments to creditors under confirmed plan is eligible for a discharge under that section. While the case law that has come out so far, the limited number of cases, seem to suggest that the debtor is not eligible, I've spoken to a number of judges who at least tell me that they disagree with that view, and other places, other districts where I'm aware that they are sort of trying to ignore the issue as best they can. But because it is such a significant issue for a debtor that's paid for 3 to 5 years to then come to grips with whether they get a discharge or not, I think there should be some clarification or some effort to settle that issue. Either I guess statutorily would be the requirement there. The third statutory fix that I would raise as a concern of mine is the definition of current monthly income under 10110A and B. And most specifically, the fact that it includes in disposable income or in current monthly income veteran benefits, which should fall under the same category as Social Security benefits and be exempt from that definition, but is not. It seems to me a very disparate treatment for that. This whole area cries out for a reconciliation between the definition of current monthly income, disposable income, and exempt property. It seems to me, it's hard for me to understand how property that often under federal statute is considered completely exempt from the reach of creditors is nevertheless included in the Chapter 13 definition so that the money is actually paid to creditors. It seems to be inconsistent to me. Finally, sort of a fix or an improvement to the statute would be some clarification of the definition of vesting of property of the estate, in my view, under 1328 1727B and C. When I did research in this area to try to determine what would be the best avenue for my district in determining a provision for the plan form, there appears to be 4 or 5 different approaches to the term of art and definitions of what it means and the effectiveness of how you make the decision of whether the property vests with the debtor at confirmation or upon discharge or other variations of vesting, which I see in form plans around the country. There needs to be some clarification of that because, again, that's a very important concept for the debtor's reorganization and fresh start. The 2 policy suggestions that I would make are concerns that are a little greater, and one I think falls within the subject of this forum today is student loan debt. I agree with so many others that the bankruptcy law rules have to provide some remedy for student loan debt, some way to manage student loan debt. Just the other day in the judge's session, a member of the administrative office indicated that debt level is now $1 trillion, and there's so many folks that are in default in their student loan debts of at least 30 days. We all know in this room that it's a growing crisis, and it's one that has to be addressed, and why the bankruptcy laws of all things can't address that debt crisis, it seems to me, effectively addressed, it seems to me, a difficult situation for us all as professionals. Clearly, the definition of undue hardship needs to be, I think, improved or addressed in the bankruptcy code. Not so much that those words are difficult to understand, but apparently they are, because we've gone so far down the road in the Brunner definition, or the case law that Brunner deals with, that at least in my circuit, it's defined as a certainty of hopelessness, and therefore student loan debt cases are impossible for us to properly administer, or at least to treat the debtor in a fair circumstance, in my view. But more interesting to me is the need that we should have Chapter 13 provisions clarified so that you can address and manage student loan debt in a Chapter 13 bankruptcy case. Most specifically, I think we need to clarify in regards to a separate classification that student loan debt can be separately classified. There are case law that varies in regards to 1322B1, and it seems to me just like the Congress defined consumer co-debtor debt and said that it could be separately classified, we need to do that for student loan debt. We also need to clarify that you can use the cure and maintain provisions of the bankruptcy code to address student loan debt, because after all, aren't we trying to encourage the repayment of student loan debt? And this is the mechanism by which bankruptcy can do that. And I think more particularly, it's a little problematic that 1322B10 requires the payment of interest on unsecured debt. I mean, if you're going to pay interest on unsecured debt, you have to pay all claims with interest. And if you cure and maintain, it seems to me inherent in that you're paying interest. And if you allow that treatment for student loan debt, then I think you would provide, at least in my view, an effective means of addressing student loan debt. Now, my last category is one that's dear to my heart, and that's just because we face a difficult circumstance in the bankruptcy courts, and that's with pro se filings. One clarification that could be made for pro se file cases is the bankruptcy rules. Bankruptcy Rule 1006 allows a debtor to pay their filing fee in installments, but it's very clear that it says that you can't pay counsel a fee until you pay all the installment payments. But for a pro se filer who may qualify for installment payments, we absolutely want them to go out post-petition and retain counsel. We want them to pay them whatever is necessary to get counsel. That is the goal. And presently it seems to prohibit that, and I think that needs to be corrected. I think for pro se filers, we have to have a consideration that the documents that they file should be simpler. I know there's been a significant effort led by Judge Harris to simplify the forms, but I think now that we have national plans, that we should allow districts who have devised their own Chapter 13 plan to have a separate, simple pro se filer plan, a plan that can make it workable for a pro se filer so they can provide the information necessary, and that be allowed under the rules. Finally, in my view, it's ironic that pro se filers, the poorest of the poor, those pro se filers who are qualified for pro bono representation but cannot achieve it, cannot get a lawyer to represent them pro bono, those are the people who can't navigate the Chapter 13 process. I think it's naive for us to think that they only should file Chapter 7 because they're very poor. Well, in fact, they're trying to keep assets, maybe the meager house, the car, that sort of asset that they have, and 13 may be important to them. We ought to have a process by which they can receive some help. My suggestion is that Chapter 13's trustees be encouraged to have the ability to offer workshops and other means to help those pro se filers who qualify for pro bono representation but can't achieve it, to have some training on how to fill out schedules, statements, and the plan. I don't think that will interfere with their ability of the trustee to be impartial at confirmation and make recommendations to me as a judge of the court about confirmability. I'm aware of districts that provide through their 13 process financial instructions. This is similar to that. There are some districts around the country, in fact, where the trustees are very active in regards to helping a pro se filer propose a plan. But what I'm suggesting is that there be some greater green light in the system that allows the trustees who have the ability maybe to provide this assistance to be authorized to do it in some way. And that would help our system and help pro se filers who have to go that route, pro bono folks, at least to have a chance to be heard in court and be fairly treated. So those are my suggestions today. Thank you.
Thank you. And now we'll hear from Judge Connolly.
I don't have any questions.
No, I'm sorry. The questions will come after both presentations. Sorry.
All right. Thank you. Thank you, each of you, for this chance to approach the commission, and thank you also for the work that you're doing. First, I'd like to note that I agree and concur with everything that Judge Waits has just stated. That reflects my views as well. What I would wish to do at this time is to address two of the issues that you had identified on your list of topics, the first being topic number 5, notice and service issues, the other being topic number 2B, payment of attorney's fees in Chapter 7 cases. And with respect to notice and service, I'm going to talk more about administrative challenges, hurdles, that I hope that this commission can help address to facilitate an improvement to notice and, I believe, service issues in Chapter 7 and Chapter 13 cases. First, consider Section 342. We have statutory authority that allows a creditor to designate a preferred address to be used in bankruptcy cases under Chapter 7 and Chapter 13. As a result, the United States Courts has contracted with a third-party vendor, the Bankruptcy Noticing Center, BNC, to collect the addresses, maintain the registry, and use that address list when serving notices on behalf of the bankruptcy court. But the challenge is that it is only the Bankruptcy Noticing Service who has access to that information. The practice has been that registry of national addresses that are preferred by creditors has been deemed to be proprietary, secret, solely maintained by the BNC. So I, as a judge, don't have access to the creditor's preferred address in order to verify whether a notice was actually provided to the creditor at the creditor's designated preferred address. Likewise, debtors' counsel, creditors, and Chapter 13 and Chapter 7 trustees do not have access to that information. Why that's important is because more courts have deferred or referred the service and notice requirement to debtors' counsel and to Chapter 13 trustees in many cases. It's fairly common in districts with large Chapter 13 filings, but it's becoming more common throughout the country. So as a result, you have third parties, Chapter 13 trustees and debtors' counsel, who are in effect performing the court's notice requirements under Rule 2002, and yet they are not able to have access to the creditor's preferred address for bankruptcy notices in bankruptcy cases. I believe that this can be solved through making sure that the National Registry is available. Let's just provide some transparency, make sure that that access to the creditor's preferred address is available to those who are using it in bankruptcy cases, whether it be debtors' counsel to notice something on behalf of, pursuant to Rule 2002 that would otherwise be a court notice or not. or maybe a debtor's motion or other action in a bankruptcy case. It simply makes sense that in the bankruptcy case, the notice to the creditor goes to the address that the creditor designated as its preferred address in bankruptcy cases in Chapter 7 and 13. To open up the addresses, it could be done in a variety of manners that could still maintain some level of security, still be a searchable database, or perhaps just a static report, but access to the courts and the public for this. In addition, though, that's not all. We know that notice isn't the end of the day. We also are concerned about service, the mechanism in which the information is provided to the creditor when the creditor's rights are affected by what the bankruptcy court is going to do. I need to ensure that before I consider whether to allow a debtor to void a judgment lien or determine an allowed secured claim, that the creditor was provided notice in an effective means consistent with Rule 7004. That means that I need to know that the service was made upon, in some cases, a named officer or director, in some cases, a registered agent, in some cases was sent by certified mail to a physical address. I don't have access to that information. Because the creditor can and will provide a preferred address under 342 for bankruptcy notices, that mechanism can be expanded to have the creditor who knows its own officers or directors, who knows its physical address, who knows its registered agent, to simply add that information to this national registry. This could be done, again, fairly consistently and easily, effectively, but whether the actual addresses are there, or maybe it's simply just where to look. Maybe it's a website address or some other place where I can look, and debtors' counsel can look, and trustees can look, and creditors can look to verify that service was made to the appropriate address or party or person. But as we all know, more and more we are not even using mail or paper notice. More and more we are using electronic means of communication and to obtain information. So it makes sense that while the 342 uses the term address, it is not limited to a physical address or mailing address. The statute simply says address. So it makes sense that when the creditor is providing its address, it includes a website, an electronic address, a cell phone that can receive text alerts or notices, any other bulletin board or other means for electronic information to be posted and shared. We know that there are services out there that scrape the bankruptcy court system and then provide that information to creditors. There's no reason why we have to let them pull it. We can simply allow the parties to push it. So that, I believe, will help to reduce costs. I think it will provide more effective and efficient service. But reducing costs is significant. Think about it. We're going to reduce mailing costs, labor costs, and printing costs. And reducing costs leads me to the next topic that I'd like to identify, and that is attorney's fees in Chapter 7 cases. It appears that we have, perhaps inadvertently, created a system in which, in some jurisdictions, low-income individuals are effectively denied access because they may not qualify for legal aid services in their jurisdiction. They may need or want to file a bankruptcy. They may not be able to afford the filing fee plus the attorney fee prior to filing the bankruptcy petition. And if so, and they wish to file a Chapter 7 bankruptcy, our approach has been to deny that debtor any opportunity to pay those attorney's fees over a period of time. So it appears that that could be dealt with in a couple of different ways. One would be to allow for voluntary opportunity for a debtor to pay attorney's fees over time, and I believe we can do so without statutory changes, or ideally with statutory changes, simply by taking advantage of reaffirmation, a waiver of discharge, along with the current oversight that we provide under Chapter 3 and Chapter 5 of Debtors' Counsel. We can use this mechanism to allow a debtor to voluntarily choose to enter into a repayment period plan for attorney's fees. And keep in mind that in doing so, that is not to alter any state law ethical laws that would be applicable. So to the extent that the attorney has limitations on the attorney-client relationship and not to become adverse with the client, that's still going to be in effect. I encourage consideration of allowing debtors to file Chapter 7, to allow the unpaid attorney's fees to be accepted from discharge, allow the debtor to voluntarily waive discharge, allow the debtor to in effect reaffirm those, and to trust that the individual, even though they are low income, that they have the ability to discern, and we in the court system have the ability also to discern when it is appropriate and when it is not.
Thank you very much. We now have a limited period of time for questions from the committee, and does anyone have any questions they wish to ask? Mike.
For Judge Waits, I wondered if you could clarify what it is that your colleagues might disagree with about Section 1328, since the code section says all payments under the plan, and the Supreme Court said in the Lanning case that it just seems to go hand in hand with me. The court said that a bankruptcy court should not confirm a plan unless it finds that a debtor is going to be able to make all the payments under the plan. What is it that your colleagues might be looking for or think that should be accepted from all payments under the plan?
Well, I couldn't really speak for them exactly in terms of just what I've heard from them. My decision that I wrote in the Dowie case in South Carolina agrees with the majority of the cases that have been written in regards to it, and it seems to me that unfortunately those debtors can't receive a discharge until they cure their failure to pay direct payments. But Rebecca may have a better answer to that.
May I?
Yes, please.
Please.
I think the difference in part may be because that when 1322 was drafted, it provided that a debtor may provide for payments under the plan to the Chapter 13 trustee, or the debtor may maintain direct payments on a long-term debt that extends beyond the plan. And originally, under Chapter 13, those secured debts were not dealt with in Chapter 13. So to maintain the contractual obligation was separate and distinct from what the debtor was providing to the Chapter 13 trustee to be paid and dispersed by payments to the Chapter 13 trustee. We have interpreted the language of 1322 as if the payments made that are to maintain the contractual obligation, as if those are planned payments. And yet, it's not clear to me, even looking at the actual language of 1322, that that's a correct reading of 1322 or that it was intended. The other thing to think about is the fact that the long-term debts are accepted from discharge under 1328. So for Congress to draft 1328 to accept from discharge long-term debts, but then turn around and provide that the failure to comply with the contractual obligation would deny the debtor an opportunity to discharge seems to be unnecessary and perhaps even inconsistent. So a closer look at 1328 combined with 1322 can lead to the conclusion that the debtor's breach of contract on a long-term mortgage debt is not by itself a basis to deny the debtor a Chapter 13 discharge when all of the requirements have been met to qualify the debtor for achieving a Chapter 13 discharge.
Thank you. Yes.
Judge Connolly, in that regards also, if I could, it seems that a large part of this problem has arisen in response to the very important and well-intentioned notice of final cure payments that happened at the end of the Chapter 13 cases, where suddenly courts are finding out and trustees are finding out that the debtor may have missed some mortgage payments. Where would your thoughts be on if that was also something that, rather than just happening at the end of the case, there were some sort of interim requirements of those of updates, because to some extent it often seems that the bank has sat on and missed 6 or 8 payments during the course of 5 years and said nothing until the very end, which submarines the case.
Certainly, I think that would be very helpful. As I understand your question, it's essentially to require a creditor not simply to respond to the notice of final cure payment at the end of the case, but also to take action during the case, prior to the end of the case, to alert the system that the debtor has not complied with his contractual obligations. While that may be helpful and potentially useful, remember the creditor has the opportunity to seek relief from the stay, and it's unclear why they would not do so if there's been a contractual violation. But certainly getting that information earlier on in the case, I think, would be very helpful. I also think that it's important for us to remember that the notice that goes out and the opportunity to object to discharge applies to all creditors, and when the creditor whose debt is already accepted from discharge doesn't object to the dischargeability of the debtor under Chapter 13, I think that's a factor that the courts should take into account when considering whether to deny a discharge to a debtor who has complied with his plan payments but failed to make all his mortgage payments or student loan payments. But you may see it differently.
No, only that I'm sure you're aware, Ed, that some districts by local rule are now requiring those interim reports by creditors in an effort to try to catch it early, and it makes some sense under this circumstance, I think.
Thank you.
Thank you. Other questions?
I have another question regarding the vesting. I certainly agree that there needs to be some clarification of the definition of vesting and maybe the definition of surrender as well, because only the 11th Circuit appears to address that. Are you, by any chance, advocating that the debtor gets to vest property back in the lender when he surrenders the property?
No, I really wasn't advocating any particular view, just to...
You'll have your time, Judge. Sorry.
Yeah. just observing that there's so many different views about it that it's problematic and for those issues when they come up, I think, in many districts.
Thank you.
I have one question. Our time is short here, and it's for Judge Connolly. I appreciate and I like your suggestion with respect to Chapter 7 fees in terms of expanding the access to the bankruptcy court system for those who can't otherwise pay. The concern I have is that everybody in this room would not do this, but I've often seen that there's one price if you pay up front, there's another price which is larger if you pay over time. And it seems to me that if you open up the opportunity to, in essence, affect the debtor's discharge by imposing additional non-dischargeable must-be-paid fees, do you see that there's going to be any need for judicial oversight either under 329 or 2014, 2016 with respect to those fees that will be charged in installments?
Absolutely, absolutely. This is not to suggest that there would not be judicial oversight. I don't think that we can ignore our responsibilities under Chapter 3 to approve attorneys' fees, to review the relationship between the debtor's counsel and the debtor. I think consistent with that, along with the disclosures under Chapter 5, 525, 526, 527, we already provide for some means for there to be certain disclosures. I think combining those two, Chapter 5 and Chapter 3, oversight and disclosure requirements would not be taken away. And so what I envision would be something that would be required for there to be oversight, just as we would for approving a reaffirmation agreement or approving a waiver of discharge. The same mechanism could be expanded to permit in limited circumstances. And what I concluded by saying that let's trust the system here, trust judges, trustees, and debtors attorneys to recognize and to be discerning and to be critical in evaluating these cases. This is not a per se everybody gets to pay their fees over time. This would be something that would be reviewed and approved, and showing would have to be made that it would be appropriate in one case and it may be inappropriate in a different case.
Thank you very much. Unfortunately, I'm sure people have other questions, but we need to move on to our next panel. We thank you very much for your statements and appreciate also the fact that they're in writing and available on the web. Thank you.
Thank you. Thank you.
All right, next up on our schedule, we're looking for the second panelist, but there's no reason why we can't start. First off, I think Neil Gordon from Atlanta. If you don't mind starting, we may put someone next to you as the time goes on, but as a good attorney, I'm sure you will ignore that distraction.
I often have trouble having anybody sit next to me, so I'm used to it.
Yeah. I understand that. I have that problem with Bob Lawless all the time.
Good morning. My name is Neil Gordon. I have been a panel trustee for about 24 years and have administered about 29,000 Chapter 7, Chapter 11 cases, SEC receiverships, and other fiduciary type positions. I'm a past president of the NABT. For many years, I chaired its amicus committee. Chaired for 3 years, or co-chaired the ABI legislation committee, and I'm a fellow in the American College of Bankruptcy. There are two topics that
We're surrounding you on either side here. So.
I'm going.
With all those qualifications, we need to kind of close this in a little bit, that's all.
So there's two topics that I want to speak about. First of all is what should happen to the appreciation post-petition of assets in a consumer case. The idea that has been bandied about is that some amount of that beyond exemption should go to the debtor, either based on how much is exempted, some proration, or some other formula. But there are legal and practical reasons why that is not an acceptable idea, and let me give you the background first. Schwab v. Riley came out in 2010 from the U.S. Supreme Court. Prior to that decision, many courts and practitioners believed that an asset could be removed from the bankruptcy estate merely by exempting the same dollar amount as the dollar placed on that asset. And that was called an in-kind exemption. However, the Supreme Court disagreed and determined that what is actually being exempted is not the asset itself, but the debtor's interest in that asset stated in dollar terms. So the asset remains in the bankruptcy estate, and the appreciation then flows to the bankruptcy estate. Circuit court opinions followed pretty quickly. The Ninth Circuit had the Gebhardt decision, which was a consolidation of actually two cases. And that was in 2010, right after Schwab v. Riley. And then that was followed by the Orton decision by Judge Ambrose in the Third Circuit in 2012. And that's significant because Judge Ambrose also wrote the opinion that was reversed in Schwab v. Riley. And both of them clearly found that in light of Schwab v. Riley, appreciation goes to the bankruptcy estate. And understandably, a lot of the consumer bar was unhappy with the decision. There was even an effort in the Rules Committee to consider a checkbox that you could check a box and that would remove the asset from the bankruptcy estate, but that did not go forward, at least not in that fashion. There are practical problems and statutory problems with this proposal. And it does a lot of violence to the balance that currently exists between the interests of debtors and creditors under the Bankruptcy Code. First, the statutory problem. A consumer debtor files a Chapter 7 case with the goal of obtaining a fresh start. Everybody hears that term. It consists essentially of two elements, discharge of all dischargeable debts and being able to retain a certain amount of property through exemptions so the debtor does not have to start all over with nothing. Many states follow the federal exemption scheme, many opt out, and some allow an election between state and federal. But the basic scheme is the same. If an asset is sold by the trustee, the debtor is paid the dollar amount of the exemption up to the amount of available proceeds. The bankruptcy estate receives nothing until the exemption has been fully funded. Once it has been fully funded, the remaining proceeds, absent a surplus case, flow to the bankruptcy estate for the benefit of the estate and, most importantly, the creditors in that estate. To provide that the debtor would receive more than the exemption amount just completely upsets that balance. and it would be done at the expense of creditors, and then you're talking about a head start instead of a fresh start. Whether the asset is sold 3 months or 3 years after the petition date, the debtor receives the exemption amount as part of the fresh start. Nothing more is due the debtor, then the creditors don't have to fund anything more. If the asset were sold on the petition date, there would be no expectation of anything more than the exemption amount. Congress made sure to take care of the debtors with the exemption scheme, but to balance the rights of creditors by providing for the estate to receive the excess. Exemptions are not open-ended. Exemptions are not merely the starting point. They are the end point for the debtor, and that's the statutory problem. The practical problems are even more dramatic and really worse. If the debtor were to receive all post-petition appreciation or any portion of it, the trustee would not be able to conduct a sale without first going before the bankruptcy court and having a valuation hearing with historical appraisals done by appraisers, all of which would essentially be paid for by the bankruptcy estate to establish the value of the asset on the petition date versus the sale date. And there are no petition date sales. Every sale is post-petition. So the creditors are being prejudiced in at least 5 ways. They would, 1, essentially fund the cost of the valuation expert. 2, essentially fund the increased administrative cost of the trustee and counsel. 3, they lose the post-petition appreciation to the debtor in full or in part. 4, they lose out entirely if the finding of petition date value prevents the sale from being approved due to a lack of benefit to the estate despite all the work that has already gone into it. And 5, buyers will not be willing to pay fair market value for an asset that must undergo this type of analysis before the asset can be approved for sale and closed. A risk premium would be necessary, further reducing the value to the estate. Eventually, with all these problems the proposal would create, it would be hard for trustees to sell anything given this uncertainty and additional cost factor. At best, a buyer would charge a substantial risk premium, thereby reducing the sale price substantially, again hurting the estate and creditors. So for these practical reasons, as well as the statutory problems, the proposal is not a good one, and it upsets too much the balance between the debtors and the creditors. And the second topic I wanted to address very briefly, which is all I have left, is these short sales of exempted assets by trustees. And I sort of started this, and so you can blame me for what it turned into, but I wrote the seminal article on this many years ago called The Art of the Carve-Out. And I had imported from Chapter 11 practice into Chapter 7 the kind of carve-outs that I had been doing in my Chapter 11 cases. But as I explained in the article, which is attached to my statement that was posted, I had limited my carve-outs to commercial properties and very expensive residential homes and other types of maybe substantial but not the most expensive homes, but only if there was a substantial carve-out. Sometimes the exception would be if the debtor is unable to make mortgage payments and the first mortgage has moved to get stay relief and the second mortgage is not going to do anything. I will do a carve-out with the second mortgage, and then I would go in and reimpose the stay against the first mortgage, and that actually helped the debtor. I'm in Georgia, a non-judicial foreclosure state. Once stay relief is obtained, 45 days later, there can be a foreclosure sale. It's very, very quick. So buying time for the debtor is actually helpful. Unfortunately, it's been distorted in the practice, and what has happened is not what I intended. Now you have some judicial foreclosure states in particular where the servicers and the mortgagees, they go in and they contact the trustee and they say, look, we want you to sell this property, we'll give you a carve-out. It's going to take us years to foreclose. And the carve-outs are de minimis, and they can be under $10,000, and by the time expenses and commission and all are taken out, there's $2,000 to distribute to creditors. Meantime, the debtor, and granted the debtor's not making mortgage payments, but the debtor could stay 1 to 3 years in the home before the foreclosure process concluded. That was not what I intended, that the debtor would lose the home over de minimis distribution to creditors. I understand why it occurs. I understand why the servicers and the mortgagees are interested in it. But I think that the proposal still overreaches. Again, you shouldn't apply it to commercial properties. You shouldn't apply it to expensive homes. So what I would propose is that there be some sort of limitation on, if you're not getting a carve-out, and it'd be up to the committee to decide what it is, and then the commission, but if you're not getting a carve-out of at least $25,000 or $30,000, to me, you shouldn't be doing it. If If you're trying to do this on a property that's only worth $50,000, you shouldn't be doing it. So I would say either, if you want to go forward with this proposal and curtail this practice which is taking place in judicial foreclosure states and is giving, quite frankly, trustees a bad name, and I don't like it, I would say you've got to have at least a certain amount in the carve-out, or the property's got to be worth over a certain amount. Thank you.
Thank you for your statement. We have a volunteer from a panel in the future to step up and fill the gap, and we appreciate that very much. The Honorable Charles Redland from St. Louis, and I believe his law clerk, Abigail Willey. Hopefully I've pronounced all those correctly, and would ask you for your statements. You can mix and match seats as you wish. I mean,
We're still getting organized.
yeah.
Thanks
Well,
for calling us early.
we appreciate, you know, no one likes to be called on before they thought. It's like being at the end of a calendar and being called first.
Since I left my substantive comments to my law clerk, it's quite easy for me, but anyway, no, I appreciate it, and we appreciate being able to present an issue today that we think is timely and may help us integrate with the district court in very unique circumstances where the estate gets heard. I'm, as he said, Charles Sketch-Renlund from St. Louis, and this is my law clerk, Abigail Willey, and we're going on our 12th year. And we are concerned and want to bring to the attention of the committee the judicial estoppel issue. Recently, there was an inbound case in the 11th Circuit where they changed their bright line rule. The case is Slater versus U.S. Steel. We have conflicts between the circuits, and we also at times have very inequitable treatment of what occurs in the case when you're dealing with lawsuits, claims, torts, and other items that have been left off the debtor's schedule that arose beforehand, and especially in this case where they went from a 7 to a 13, and you can't figure out who is prosecuting the claim. So in this particular issue, as we all are aware, judicial estoppel is the equitable doctrine that prevents a party from relying on a representation that is inconsistent with the representation made by the party in a prior proceeding. They left it off on causes of action or proceedings, and this happens often. But recently, the 11th Circuit, sitting en banc, considered the test to be applied by the U.S. District Court in determining whether judicial estoppel applies to a claim brought in district court by a consumer debtor. And when the claim was omitted from the schedules filed by the debtor's bankruptcy case, they decided not to apply the bright line rule which exists in 2 circuits that judicially estops the debtor from asserting the same claim in a later proceeding. And according to Slater, they switched this and allowed the court and asked the district court to consider, under the totality of the facts and circumstances, was the debtor gaming the system? And the 2 circuits that are absolute on this issue, if you leave it off the schedules and then you file later or try to prosecute a claim, then the debtor is judicially estopped from asserting this claim just because they left it off their schedules. So here, Slater's adopted something more akin to what they do in the 9th Circuit, the 6th Circuit, and I think we also read that maybe the 1st Circuit had some original cases that looked at totality of circumstances. Now, what we want to do is to figure out how to proceed and use the expertise of the bankruptcy courts to help the district courts in figuring out what the totality of circumstances really are. And we should have that discussion. And we want the district court to consider using their abilities to send matters to the bankruptcy court for assistance in this area. Now, I use those terms lightly because different local rules, different circuit rules can apply. Some places have them more codified, other places just have an informal local agreement, and it often has to do with the trust between the district court and their bankruptcy judges. And at this point, I'm going to turn it over to my law.
Thank you. My name is Abigail Willey. I've served as His Honor's law clerk for about 12 years. I don't consider myself to be a consumer bankruptcy expert, but I appreciate the opportunity to address the Slater matter before the Commission today. Why do we care? We care what Slater says because this happens all the time in consumer cases. You have consumers who omit for one reason or another a claim and then later need to go back and amend it. The question is, what does that mean in terms of being able to bring that claim in another context? Slater has opened up the opportunity for the bankruptcy court to do something really relevant and important here on the issue of judicial estoppel. Slater made it clear that the U.S. District Court can consider what the bankruptcy court has in terms of findings of fact related to the effort to amend the schedules. So as the bankruptcy court, we have an opportunity to make a record clear. Now, as we know, in general, there's not a record as to intent when when a debtor attempts to amend the schedules. Under the rule, we let them amend as long as the case is open. However, of course, it gets more complicated when the case is closed and they have to file a motion to reopen the case. When that happens, it seems to me under Slater, it would be worth the court's time to hold possibly a hearing and take evidence and make a record so that if it ever comes to pass that the U.S. District Court needs to consider what was before the bankruptcy court in terms of findings of fact, that record is there. Now, it's going to take some time, and it's going to be an encumbrance on the bankruptcy court, but it could provide the U.S. District Court the necessary information and spare the U.S. District Court from trying to pick through the bankruptcy court record, or possibly worse than that, have to rely on the parties before the U.S. District Court to determine what facts were found at the bankruptcy court. Another possible proposal would be to amend the rules, possibly the statute, more likely the rules, to allow the district court to direct the bankruptcy court, its arm, to make a record of facts or some other type of document to send up to the district court, so that there is a finding by the bankruptcy court, or proposed finding by the bankruptcy court, that records what happened before the bankruptcy court. The U.S. District Court can then accept it, reject it, modify it, but it will have something from the U.S. District Court in a formal way that sets forth what happened at the court below. The other option, of course, is something somewhat more radical, but it would be a change to either the rules or the statute to provide for a definition, a better definition, a uniform definition of bad faith intent. Excuse me. I want to make sure I get this right. I apologize. Excuse me. I lost my place in my notes. Last, the rules or the code could be permitted to provide a uniform standard for determining whether the addition of the previously omitted claim was made in, let's put it in good faith rather than in bad faith. Slater demonstrates the need for such a uniform standard, as His Honor pointed out, because there's been circuit splits. In some circuits, the standard requires a bright line. In other standards, it doesn't. In other circuits, it doesn't. Further, this isn't just the district court that may need evidence of the debtor's intent. A case trustee could also seek a determination of the nature of the debtor's intent when the debtor seeks to add previously omitted property and then seeks an exemption. The code and the rules can be amended to include standards that would be consistent with Slater. Honestly, when I read Slater, I thought it was absolutely dead on. Judicial estoppel is not a tool for creditors to swing, a sword to swing. It's an opportunity for the court to protect itself. So I suspect that judicial estoppel has probably been inappropriately used to advantage creditors when it's really supposed to be an instrument that's used for the court's own protection. The provision could also include a non-exhaustive list of factors to consider in determining good faith, which would include the amount of time that the claim that has passed since the claim has been omitted, the amount of the claim, whether the debtor had actual knowledge of the claim, the circumstances under which the omitted claim was discovered, the trustee's position on the issue of the debtor's intent, and whether the debtor seeks to exempt the property in its entirety. Thank you for this opportunity to speak with the Commission. I hope I came in on my time.
Thank you very much for both of you. And questions from the committee? I actually, since there are none, I'll invoke the power of the chair. To Judge Redlin and Ms. Willey, you mentioned it at the end, but one concerns I have in these cases is, again, if it's an unintentional omission, a lot turns on whether it's exempt or not, right? If it's a unadministered, non-exempt asset, it presumably stays in the estate, and the real party in interest is the estate representative, the trustee, right?
In a Chapter 7, yes.
In a Chapter 7 case. So, with respect to that, it would seem to me that your proposal would probably want to involve the estate representative at a relatively early stage.
Let me allow His Honor to address that first.
That's the problem. In district court, that doesn't always come up. They don't even know it. It's after the fact. The employment defense attorney has already invoked this, and the district courts dismissed, found summary judgment for the particular.
Well, it seems to me what
defendant.
you want to preserve the claim for relief for the estate, but necessarily deny the debtor either on real party and interest grounds or in cases of bad intent, judicial estoppel.
And that has come up before when we've had personal injury cases left off in the necessary negotiations between the trustee and the debtor. And that can all be done in the context of the bankruptcy court and has been done before. However, we're talking about, this was an employment case, and in this case, they used it as an absolute. Also, it was a 13, and you didn't necessarily have the trustee in the same position as in a 7, although the estate would definitely be a beneficiary. So it's one of those unique circumstances where you guys have a lot of things to talk about.
That's not so unique in my experience, but but I understand. Any questions? Yes, please.
Mr. Gordon, could you just give us your thoughts on, in regard to the appreciation, your thoughts regarding both whether there's just simply passive appreciation of assets or active appreciation, that especially if that can be traced to the debtor's contributions, and whether including payment of secured claims, mortgages, insurance on the property, or building a sun deck on the house?
Well, in concept, it shouldn't matter. The appreciation is the appreciation. But if you're talking about is it created by the pay down of the mortgage over a period of time, you have to balance that from an economic standpoint. You have to balance that against what the cost would be to the debtor of living in a similar place, and what would it be paid.
But in general, in a Chapter 7, the debtor's wages aren't an asset, so they would have been able to keep them if they lived on the street or lived with their mother, correct?
We're not talking about living on the street. We're talking about living in a comparable property and contributing to that. You have to balance it out. It's like you don't get to charge the cost of a rental property without looking at the rents that you receive. And so when some trustees and some courts will do that sort of economic balancing, and some will just look at it straight from the situation of appreciation. And, I'm not really answering that. From my perspective, they tend to balance out the cost that you pay, the expenses that you pay and the costs that you would have incurred if you had lived in a comparable property elsewhere. So I haven't seen one yet where that has been challenged and the debtor came out with anything extra from that perspective. And of course, we all know that the debtor at any time can file a motion to compel abandonment if they think it's taking too long. The cases where that happens, and when I'm the trustee, are usually the ones where the debtor has not cooperated and has not allowed the trustee's professionals or the trustee to get into the property, to see the property, and you file a series of motions with the bankruptcy court, motions to compel inspection, motions to compel turnover, motions eventually could even lead to the U.S. Marshals. But those are the ones that we usually see it done in, is where there's no cooperation, and then it's like, hey, you've taken too long. Well, it just doesn't work that way. Sometimes it can be an asset that is very difficult to sell, and it does take a long time. But you can always file the motion to compel abandonment and put it before the court, and you can raise the issue that you're talking about and let the judge decide it.
You wish to follow up?
No, that's it. Thank you.
I guess I would like to follow up just a little bit on that, and that is, I take it that your proposal doesn't cover those types of exempt assets that do not have a cap on value?
No.
So
You're talking about
so for example, homesteads in Florida or Texas or that great state of North Dakota.
Well, I tell
which,
you,
by the way, has unlimited homesteads as well.
it's not relevant in a state like Florida where the Constitution has that embedded, because all the home is going to the debtor regardless of its value. What really happens in Florida is more the other topic that I spoke. There's quite a few trustees there that are selling out these homes, even though it can take a year to 2 years to do a foreclosure. And maybe the debtor could come up with money before it was over. You don't know. Maybe you're on the upside of the market and things will change. Instead of being undersecured, maybe the lender will be oversecured. Maybe there could be refinancing. If you sell it and have $2,000 to distribute to creditors and the debtor loses the home, then that opportunity is lost. But I view that more in terms of the other issue.
All right, and I take it that we saw over the last 15 years as property prices increase, for example, in California, lots of debtors' counsel would early on in a case either move for abandonment or move for a valuation under Rule 3012 to establish a value and cut off the trustee from any appreciation. Your proposal would eliminate, would take out from that the legal basis for that maneuver, correct?
I lost with all the noise that just happened. I lost the whole last part of what you said.
Well, and also I was rambling, which I often do. The point is, right now, with the issue uncertain as to who gets the appreciation, a well-advised debtor's attorney might move quickly for abandonment or valuation on the contention that, listen, the appreciation belongs to the debtor, not to the estate, and I want to make that clear either through abandonment or through a valuation. If your proposal is adopted, the legal basis for such motions would no longer exist.
Well, it would depend. If you're talking about that the value is already less than the, at the time early in the case you're talking about, is already less than the liens and encumbrances and the exemption, there's nothing wrong with moving for abandonment at that point in time, because you can make the argument that it is it's an inconsequential value, burdensome to the estate, right. All of those, and so it doesn't eliminate that at all. But if there's already equity beyond all of that, then you're never going to get the abandonment approved by the court, because it's not going to be of inconsequential value. And let's say it's just a house, it's not going to be burdensome to the estate. But if it's an expensive home, I mean, in the millions, it could take years to sell. I mean, they don't sell like a $250,000 cookie cutter home in a subdivision.
All right, I think we're out of time for this session. Join me in thanking our panelists, especially those on short notice. We will adjourn the committee meeting for 15 minutes. We will reconvene here at noon, 15 minutes. Thank you.